Alrighty, hello everyone and welcome. My name is Sarah. I'm with the Shelter Island Public Library, and this program on Know Your Rights concerning landlord and tenant laws is put on in conjunction with the Shelter Island Town Social Work Department. And I'm not sure if Allah's here, but hi, Allah, if you are. And I'm here with Legal Hand and Judge Fern A. Fisher, who is the Executive Director of Legal Hand Incorporated and a visiting associate professor of law at the Maurice A. Dean School of Law at Hofstra University. Until July of 2017, she was Deputy Chief Administrative Judge for the New York City Courts and also served as the Director of the New York State Courts Access to Justice Program. She was in charge of the New York City Housing Court for over 21 years. And that is an incredible resume. And with that, I'm going to turn it over to Judge Fisher.
So I want to thank everyone for being with us tonight, particularly since it is Friday and it's 4:30. And I'm sure you're giving up some great activities to be with us tonight. I am going to try to address the issues in a global way so that both landlords and tenants who may be participating today can get something from the presentation. We will have a short question and answer period at the end. I cannot answer specific cases, but I can give you generalities. Okay, and so just also to clear up things so that you're not confused, I'm a retired judge. I retired in 2017 to join the faculty of Hofstra Law School. I started working for Legal Hand in 2021 and as the head of the Nassau Suffolk Call-in Center, and now I'm in charge of all of the centers. We have 6 of them. Okay, so let's get started. You can put questions into the chat if you know how to do that. And then when I finish going through the PowerPoint slides, we'll take the questions in turn. Okay, does that work for you, Sandy? Or Sarah?
Yep,
Or
that
both?
works perfect. Works perfect.
Okay, great. So let's get started with the presentation. Sandy, let's go back to the PowerPoint. It was on the screen a minute ago. There we go. Okay. We're almost there.
I apologize about the technical difficulties. I lost the internet very quickly, but we're back on. So sorry.
Okay, no problem. We all have that problems. Okay, so let me just say a little bit about Legal Hand. So those of you who don't know about us, learn something, but also know enough that you know that you can reach out to us after this webinar if you need help. So Legal Hand is a not-for-profit organization. All of our services are free. We do not have criteria for services. In other words, it doesn't matter what your income is. It does not matter what your immigration status is. We deliver legal information, referrals, and resources. We also help with some court forms. Our number one area of calls is housing. After that, it's family and probate and administration, consumer debt, um, and then the rest is sort of assorted. We use community volunteers who consist of people who are from the community or local colleges and law students from Hofstra Law School. So what we like to say is that we're neighbors helping neighbors or community members helping community members. Our goal is to provide information that will help people deal with their cases and empower them to seek justice on their own if they have to, if they can't afford to get a lawyer or they're not able to get a legal aid, legal services attorney. Okay, so we're going to dive right in. And this is something you may not know, that regardless of what your lease or your agreement is with your landlord, every tenant has the right to a livable, safe, and sanitary home. That is written into the law. And as I said, it applies whether you have a written lease or an oral lease or no lease at all, just a month-to-month tenant. You are entitled to a habitable apartment. Any lease that has you waiving that right away is non enforceable and against the law. So typical violations are what we call breach of warranty of habitability, or some of the things that you may be familiar with: no heat or hot water, or insufficient heat or hot water, pest or rodent infestations, and pest includes bed bugs, roaches, ants, things like that, rodents, mice and rats, occasionally a raccoon or two. Mold, black mold is very dangerous to health. Don't overlook it. If you have black mold and where you're living, you should be trying to get that remedied. Water leaks, electrical problems, sagging floors, broken windows or locks, are all very typical repairs that constitute the breach of warranty of habitability. I should also add to the list paint that's flaking off the walls can also be a breach of warranty of habitability. Okay, so what do you do when you have something wrong with where you live? All right, so you're going to make sure that you document the things that are wrong with your apartment by putting all your requests for repairs in an email, a text, or certified letter. If you and your landlord have been communicating by email and you know that the email that you're using belongs to the landlord, then you can email the landlord, but then you're going to have to, make sure that you preserve the email. Texts don't last for so long, so be careful if you're texting, because you want to make sure that you have a copy of the text. And certified letter may not be necessary right away, but if you're not getting any responses, then you might want to send the letter certified. You want to keep copies of all the communications. And in most cases, it's going to be an individual landlord on Shelter Island, but there may be a property manager. So the communications can go to a property manager if that's the person that's responsible for making the repairs. You're going to take photos and videos of repair issues. You can't take videos of heat and hot water, obviously, but something like a broken window or leaking faucet, you can take photos of it. The good thing about our cell phones is that you can get the date on the photo. You also want to keep a log. So when you say a log, why would you keep a log? Well, you should keep a log of the heat and hot water in particular. Get a thermostat and see thermometer, excuse me, not thermostat, thermometer, and get the temperature of the room and the temperature that's on the thermostat as well, the date that you're making the entry, and keep a log. The water, again, the same thing. Water has to be at a certain temperature. I don't have the degree in front of me right now, but we can provide that to you later on. But the water has to be at least a minimum temperature that's required by the law. And generally, it's the health department that handles heat and hot water problems. All right, and if after you've asked for the repairs and after a reasonable period of time, they have not been done, you can file a complaint with your local code enforcement agency. So in Shelter Island, the code enforcement responsibilities come under the buildings department. Okay, we go to the next slide. Okay, so let me give you a heads up about filing complaints with code enforcement. Depending on the nature of the problem, in your place that you're living, by bringing it to the attention of the code enforcement people, if it is so dangerous it cannot be fixed, or your owner does not have a certificate of occupancy, the buildings department can actually order you to vacate. So it might not have the desired effect. You might end up having to move because of whatever is wrong. But that's for serious, things that are wrong, serious code violations. But you do want to be careful. Um, if you need some information on that, you can call Legal Hand, or you can try calling Long Island Legal Services as well. All right, so if there, other than calling code enforcement, because depending on where you live in Long Island, code enforcement can be very slow to do anything about complaints. Some of them are better than others. You can do one or two things. Um, One is repair and deduct, and you have to be very careful when you're doing repair and deduct. So you should only repair and deduct, and that means you're going to fix it yourself and deduct the cost of the repair from your rent. You want to do that only after you have reached out to the landlord more than once to get the thing fixed, and the landlord has refused or ignored your complaints, and it's not reasonable to allow the condition to continue, and it's an emergency. So if your toilet is completely clogged and it won't flush, for example, that's pretty serious, and your landlord is refusing to fix it. You can call in a plumber and get the toilet fixed, and then deduct the cost from your rent. However, if the landlord sues you in court for the rent that you have not paid, you have to be able to prove that the repair cost is reasonable. So, getting more than one estimate of how much the repair will cost helps you establish that the repair is reasonable, and make sure that you keep the estimates and all of the invoices and receipts. All right, the other thing is withholding rent. All right. Okay, so if you are on public assistance through the Department of Social Services, or you are on Section 8 and you have a voucher, you should talk with your caseworker first before you withhold your share of the rent. Um, in some cases, public assistance, and in other words, Department of Social Services, can take the rent off the budget and will not send the rent to the landlord. And in real serious cases, the housing authority, the individual, I think it's CDC for Shelter Island, is not going to pay the rent if the repairs are that bad. All right, so the most important thing is notifying the landlord and keeping proof of the notification and waiting a reasonable time for the landlord to fix it. And then you must give access to the landlord to fix whatever needs to be fixed. And it's reasonable access. So if the landlord wants to do the repair at 4 o'clock in the morning, unless it's something like cascading leak, and even that 4 o'clock in the morning may not be reasonable, you should let the landlord in to make the repair. Let's do the next slide. Okay, so when you're withholding your rent, eventually that may end you up in court in an eviction proceeding. So that's why keeping proof is extremely important. So when the screen says don't withhold too much, don't so if the toilet cost $100 to fix, you shouldn't be withholding more than $100 from your rent for the repair of the toilet. And then whatever the money is that you are withholding, you want to hold it till everything is resolved. Depending on how much is involved, it might result in an eviction filing. And we'll talk about the kinds of eviction cases later on. And in court, the judge will decide how much the rent reduction should be. So even though you paid $100, it's a possibility that the judge may say it's only $90. So that's why you want to have the whole $100 put aside. And judges have discretion when deciding how much to reduce the rent. So it may not be just the amount that you spend on the repair, but if, for example, you had no heat in the middle of the winters, particularly this winter when we had 15-degree weather, and you had no heat for the entire cold snap, the landlord will reduce your rent based on the numbers of days that you had no heat. So lack of heat and hot water would be considered serious usually. Most judges will give 50 to 60% off per day for each day you had no heat. Some judges might give a little bit less, 30% for a moderately serious problem, and 10 to 20% for a minor problem. All right, so who decides what's minor, moderate, or serious? The judge. Okay, so keep in mind that the amount that the judge may give you off is dependent on the severity of what was not repaired, but also if you withheld the rent also and made the repair yourself, whether or not the repair was reasonable. So it's two things operating at the same time. Let's go to the next screen. Okay, so there are defenses to both kinds of eviction cases. There are two kinds of eviction cases. There's a non-payment case. That's where the landlord is suing you for not paying the rent. And that's the only issue, is not paying the rent. And then the other kind of case is called a holdover case. All right, so a holdover can be based on a number of things. It could be based on the fact that you're actually not the tenant, that you are um, a remaining guest. In other words, the tenant was there, let you into the premises as a guest, maybe you're a boyfriend or a girlfriend, and then they left. You're then called a licensee, and you can be evicted because you were not the tenant that the landlord, rented the rent to. Illegal sublets come under holdovers. Squatters. Often, for those of you who are landlords, people will also call us and say, I have a squatter. But when we ask more information and we get the facts, they're not actually a squatter, they're a licensee. A squatter means that the person entered onto the premises without the permission of either the landlord or the tenant. They're trespassing, basically. And we've seen some of this in the news more recently. And so a holdover can also be brought on the fact that your lease is over and the landlord no longer wants to keep you as a tenant, or you're a month-to-month tenant and your monthly rented has come to the end of the month. It could be that you're an undesirable tenant, meaning you make too much noise, or you're keeping the premises in a filthy condition, or you are selling drugs, or you're doing something else that makes you an undesirable tenant. You're fighting with the neighbors, something like that. And so therefore, the landlord will decide which kind of case to bring, based on the facts and based on what is in the landlord's interests, to make sure that the eviction goes through and it goes through as quickly as possible. So if you make a good faith complaint to the landlord, the landlord's agent, or the buildings department about repairs, um, except in small owner-occupied dwellings, the tenant can raise retaliation as an affirmative defense in an eviction. It is going to be more successful in a holdover. It's not going to be successful generally in a non-payment case. So you can use retaliation. So for example, you're a month-to-month tenant, everything's going fine until you make a complaint about repairs to either the landlord or the buildings department or the agent. And then all of a sudden the landlord seeks to evict you. And if the eviction retaliation happens within 1 year of the complaint, and the landlord starts a case against you, uh, either by serving a notice to quit, um, which is what you need in a holdover, and then starts a court case against you, or offers a new lease with an unreasonable rent increase in order to retaliate, or attempts to substantially alter the terms of the tenancy after you've filed a complaint. If the landlord does prove a non-retaliatory reason, then the petition will not be dismissed. It says should be dismissed. So it's on the landlord's burden to prove that there's a non-retaliatory reason as to why they're trying to evict you. And if that's the case, the petition will not be dismissed. Okay, let's go on to the next screen, Sandy. Okay, so what are defenses to a non-payment? And a defense to a non-payment are generally repairs, breach of warranty of habitability, repair and deduct, or that you have paid some or all of the rent. Those are the basic defenses, or the rent that the landlord's suing you for is not the agreed upon rent. So you agreed to pay $500 a month, and the landlord's suing you for $600 a month. So those are the general defenses in a non-payment case. Out in Suffolk County, in particular, with small buildings, it is more likely that the landlord's going to bring a holdover proceeding because they don't want you, or the landlord does not want the tenant. And if the tenant pays the rent, the landlord has to keep the tenant. So they'll bring a holdover proceeding instead of a non-payment. So we see more holdovers in Long Island, particularly on the eastern end of Long Island, than we do in, for example, the city or Nassau County. All right, so what happens at a trial? At a trial, there's testimony, which is under oath. And so you can bring in your pictures, you can bring in somebody else who heard you tell the landlord about the repairs, or other people who've seen the repairs, other tenants that have the same problem. You can bring in your documents. Now, bringing in documents can be difficult because you have to bring them in the correct way. And you have to have a foundation and get them into evidence. And it's not always easy for somebody who's not a lawyer to figure out how to get something into evidence. Like, for example, inspection reports cannot just be printed off the net and brought it in. They have to be certified copies. So you have to get a certified copy of the inspection report, or you have to subpoena the buildings department to have the inspector come in. All right, photos and videos have to be um, a reasonable reflection of the condition, so they need to be clear, and they have to be from the time period in which you are asking for a rent reduction. There are very few trials uh, in housing cases. They're not that easy to do. But it is possible to do it without a lawyer. Legal Hand can provide you with some information. We can't tell you how to necessarily present your case, but we could give you the tools to be able to do it. All right, and you see at the bottom it says the court will not look in your cell phone. You can't pull up your cell phone and pull out the text. Okay, so you have to print the text out, and you're going to have to lay a foundation as to where you got the printout from, that the number that was texted was your landlord's number, how you knew it was the landlord's number, so forth and so on. Okay, let's move on past the trial. Okay, so if you are going to trial, the standard of proof on both sides, both for the landlord and the tenant, is that you must prove your case by a preponderance of the evidence. Okay, so, that's a legal term. What does that mean? So you've heard criminal cases. In a criminal case, the DA has to prove the case beyond a reasonable doubt, which is a very strong standard. But preponderance means that if you're looking at a scale, and I know you can't see my hands, and I don't want Sandy to take the PowerPoint down. If you think about a scale, and think about a scale that has two sides, like the scale of justice, and they're even, right? In order to win, the one side of the scale has to be lower than the other. And so the part of the scale that's higher is the winner. So it's only 51% probability that you win. Okay? So for a landlord, what are the defenses? All right. So in a case where the tenant is raising repairs, the defense is that the conditions were not proven, that the landlord had already fixed the conditions, that the condition was tenant caused or guest caused. You're not entitled to a rent reduction if you caused the repair yourself. So if your kid put one of their stuffies down the toilet, um, I was thinking about that little orange orangutan that little monkey was playing with. That's pretty big to go down the toilet, but one of those little beanie bag things down the toilet, and that's the reason why the toilet was clogged. That is on the tenant, and the landlord still has to fix it, but there is no rent reduction for it. And the other defense that happens and is raised quite often in cases is that the tenant would not allow the landlord in to make the repairs. And sometimes tenants don't allow the landlord in to make the repairs because there's bad blood between the owner and the tenant. They don't trust the landlord to do the repair, or it's an unreasonable hour. But it then is your burden as the tenant to prove that there was a good reason for not allowing access to the owner to make the repair. I have seen in my background as I was a legal aid, legal services attorney before I became a judge, where the tenant was not letting the landlord in because the landlord was sexually harassing the tenant. So that could be reason for not allowing access. Unreasonable hours or reasonable time, no notice, can all be reasons for not giving access, but it's the burden on the tenant to then establish to the judge that there was a reasonable reason for not letting the owner in to make the repair. Okay, let's go on to the next slide. Okay, so another kind of case that happens in eviction courts, or in your case would be the town and village justice courts, is illegal eviction. Okay, and that is now a misdemeanor, a Class A misdemeanor, and that if the landlord forced you out without a court warrant of eviction. Okay. And there's two ways of forcing you out: changing the locks, so that you can't get in, or doing things to force you out, like cutting off all the essential services, like the lights and the gas or the heat and the hot water, taking your belongings from the house. Here's the one that says removing the front door from its hinges. He was like, who would do that? Well, it has happened. So that would be considered an illegal eviction. Scaring the tenant by leaving. We had one where the owner was leaving voodoo, I don't know what you call them, artifacts, at the tenant's door, and the tenant got scared. So anything, including changing the lock so you can't get in, but trying to force you out can be considered an illegal eviction. And as I said, it's 30-day, it's a Class A misdemeanor, but you have had to have lived there for 30 or more days in order to be able to raise that. Now let's go on to the next one. Okay, so the penalties for illegal eviction are $10,000 per illegal act. There are also daily penalties, and there's criminal charges. So I am not aware of whether or not this has actually happened in your jurisdiction. Sarah, maybe you're aware of anybody who's actually been illegally evicted and gone to court and won. But the first thing you should do is call your police department. It is not far-fetched that the police department will say, you got to go to court, file an illegal eviction case. We're not getting involved, but call the police anyway so that you have it on record. You can file an illegal eviction case in the Town of Village Justice Court. You can file a complaint with the New York State Attorney General's office. You can sue for damages. And if you know there's bad blood between you and the owner, keep proof with you at all times, in your wallet or your purse, your pants pocket, whatever, that you've lived at the home for at least 30 days. So a utility bill, cable bill, electric bill, gas bill, something like that, voter registration, to show that you've actually lived there more than 30 days. Okay, so in 2020, the New York State Legislature passed some new laws to strengthen the rights of tenants. Some of the laws that have passed since you may have heard about in the news, but do not apply to Nassau and Suffolk. So I will only be talking about those that apply to Nassau and to Suffolk right now. Okay, if the landlord decides not to renew a lease or to raise the rent by more than 5%, the landlord must give the tenant a written notice. And if you live there less than a year, it's 30 days. So if you're a month-to-month tenant and your rent is um $500, and the next month the landlord says, no, 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 now I want $1,000. Okay, that's more than 5%. So 5% of $500 is $25. If they raise it $25, they can get that. But otherwise, they have to give you 30 days notice before they're raising the rent more than 5%. If they're trying to get you to move and you've lived there less than a year, they only have to give you a 30-day notice to terminate. If you've lived there 1 to 2 years, it's 60 days, and then the maximum is 90 days. Right now, that is for a holdover proceeding. Okay, in order to start a holdover proceeding. This is what is called a predicate notice. The landlord can't go into court unless they have given you a 30, 60, or 90-day notice if you're a tenant. If you're a squatter, it's called a notice to quit, and it's 10 days. All right, squatter means you had no right to be there at all. Or if you're a licensee, meaning you were a guest, you were allowed in there by the tenant, you're not the tenant, it's 10 days notice. These 30, 60, 90-day notice requirements are for tenants only. In a non-payment case, the landlord must give you a 5-day rent reminder by certified mail. And it's basically saying, your rent is 5 days past due and you owe me, whatever amount you owe us. Please pay or else we may have to evict you. And then after that, and that only has to go by certified mail, it's a 14-day rent demand, which must clearly say what you owe and must clearly say that you are must pay up within 14 days or else you're going to be evicted. Okay, so you see that it says includes the good cause eviction notice. I want you to ignore that. That is for the rest of the state. We do not have the good cause eviction notice requirement in Suffolk or Nassau. So that part, we see where it says the good cause eviction notice does not apply in Suffolk and Nassau. So the only thing they have to do is to demand the rent. All right, so the 14-day rent demand must be served. Okay, it can't just be given to you by the landlord. Landlord cannot hand you a 14-day rent demand himself. Somebody else can hand it to you in person. But if it's not in person, it has to be served pursuant to the law. And that is either, taped on the door, and then mailed by regular and certified mail, or it can be served on somebody who lives with you or works with you in the place that you live. It's a little bit more complicated, but it has to be served. If you have any questions as to whether a 14-day rent demand was properly served, you can call Legal Hand and we can give you the law on that. Let's go on to the next one. Okay, so the other protections that were passed were the retaliation, which we went over already. The rent is not late until 5 days after the due date, and the late fees were capped. So they can't charge you more than $50 or 5% of the monthly rent. Security deposits are capped at 1 month's rent. Landlords that are asking for more than 1 month or are not complying with the law, file a complaint with the New York State Attorney General's office. And then after are moving out and you want your security deposit back, um, the landlord must give you a in writing the alleged things that were wrong and the deductions that he or she or it are taking out of the security deposit. All right, hold on just a minute. Um, so in Shelter Island, you cannot rent an apartment or house unless there's a certificate of occupancy, and you cannot rent to more people than the certificate of occupancy allows, and you cannot create more bedrooms than what's on the certificate of occupancy. Without a certificate of occupancy for the rental property, you also cannot collect rent. It depends on the judge as to how that's handled. Most of the time, the judge will dismiss the case. And some judges will not allow you to bring a holdover either if you have no certificate of occupancy. Depends on the judge. Also, in Shelter Island, the landlord must register with the buildings department in order to rent a premises. Okay, so other protections are you have a right to move your family in as long as it's not overcrowding, because you can only have a certain amount of people per bedroom. And children under 3 don't count towards that number. Um, and the landlord cannot refuse to rent to you if you've been involved in a prior landlord-tenant dispute. Okay, let's go to the next screen. And these are some of them are all new protections that were in the 2020 law. All right, so um, a lot of people are not aware that the law it's only in Suffolk County. So if there's any Nassau people, this does not apply to you. In Suffolk County, pursuant to the Suffolk County Code, Chapter 696, Article 1, in your first lease offered to the tenant must be for a full year and it must be in writing. This can be waived by the tenant, but it must be in writing. So, for example, for summer rentals, that's fine, but the tenant has to agree that it's only for 2 months and it has to be in writing. Let's go to the next screen. I think this might be our last screen. Oh, Um, there are a couple places that you can go to look for help. You can go to Eviction Defender New York, under Law Help New York, where there's information. You can go to Long Island Legal Services, which for you would be the Riverhead office. If you're in Shelter Island or East Hampton or Sag Harbor or Southampton, you go to Riverhead. They also have an office in Islandia and Nassau, but you would go to Riverhead. You cannot go to Empire Justice Center directly. You have to go to Long Island Legal Services first, and they will refer you to Empire Justice Center. But their numbers here just in case. And of course, go to the next screen, Sandy. You can call Legal Hand. All right, so Legal Hand is open every weekday. Our hours are Monday from 12 to, I think it's 12 to 7. 12 to 8, I'm sorry, 12 to 8. Tuesday, Wednesday, and Thursday, 10 to 4. Friday from 9 to 12. So there's one night. So if you're working and you can't call during the day, you can call us at night on Monday nights. We also do legal forms right now on Monday nights. There is a phone number for Suffolk. If you're from Suffolk, use the 631 number. Our email is there, and you can also text us. And we do answer texts and emails. So If you don't have the time to call or you're shy, you don't want to talk to somebody, you can email us or text us. But sometimes we have to ask you to speak with us anyway because you can't get the entire story in an email or a text. And so therefore we still need to talk to you. But it depends on the case. Okay? All right. So we will spend some time, the next 15 minutes, taking some question and answers. So let's see. Let me
Yeah.
go to the chat and see if I can figure it out.
Oh, no worries, Judge Fisher. I'm here as well, so I can also read the chat. Right now, it looks like there's no particular questions. There was a concern about withholding portion of Section 8 rent portion, and the commenter did mention that the HA can withhold their portion.
Right.
Many renters withhold their portion, which jeopardizes their voucher.
Yes, that's what I'm saying. You have to be very careful holding you. That's why you have to talk to your caseworker before you withhold your share of the rent. You can't withhold the voucher. That comes directly from the CDC. So you can't stop that. They might stop it if your repairs are that bad, but and then they're not going to allow you to use the voucher there into the future. But stopping your share is a little dicey, and it would be better to pay it and try to get the money back in court. But sometimes, you have an owner that's not responsive. That's the only thing you can do. But please talk to your caseworker before you do that.
Yeah, let's see. No, if anyone does have any questions, there's plenty of time. Feel free to type them in the chat. Um, Mostly we're just seeing some comments. And so just for the folks tuning in, there are like 6 Sarah Garcias in the chat. They're not all me. I apologize about the naming issue. But
Oh, that's okay. That's
yeah,
fine.
it was when I sent out the link. I goofed on my end.
Not a
But yeah,
problem.
we've got a great presentation. Many thanks.
And remember, you
Let's
can
see. Oh,
call us. Does Nassau County have a?
yes.
No, no, Nassau County does not. But Nassau County has rent stabilization and rent control, which Suffolk does not have.
Yeah, and
So,
I'll just read the question that you just answered out loud because I realized
mhm.
we're recording. The question was, does Nassau County have a comparable ordinance or regulation to Chapter 696, Article 1 of the Suffolk County Code? So,
And
Judge
again,
Fisher's
I'll repeat
answer.
it. The answer is no. But Nassau does have rent stabilization and rent control, so you always have to check to see if the apartment is subject to rent regulation, and there are other laws that apply to those kinds of apartments. Although I doubt if there's any rent control apartments left. The last time I did a Freedom of Information request to find out how many rent controlled apartments there were in Nassau, they said there were 5, and that was 5 years ago.
Yeah, there was a follow-up comment that says CDLI is not the only ones who administer Section 8. They changed their name, and not all of Nassau has rent stabilization.
There are very
So,
few rent stabilized units in Nassau. I think there's 50, there
yeah,
were 1,500 5 years ago. And if I said CDC, I'm sorry, I have CDC on the brain because it's in the news so much. I meant CDLI. I don't know who else administers Section 8 for your area, but Sarah can contact us in the future and we can look it up.
definitely. We have another question. Living in private senior housing for 12 years, I have many allergies to the carpets, and landlord previously removed rugs for me at a low cost. Now I will be transferring to a ground floor apartment. Do they medically have to remove the rugs again? I have all the doctor's demand letters to remove the rugs, or should I be responsible for any of it?
Okay, so cannot give you legal advice, but I can give you general legal information. So, your allergies might be considered a disability. If you have medical documentation for that, you might be able to compel the landlord to remove the carpets. Is this wall-to-wall carpet?
Mm, waiting. Yes,
Yes.
it is wall-to-wall carpet.
Yeah.
Yep.
Okay. But you have to have a medical documentation.
All right. Does anyone else have any questions? Got some thank yous coming in. Oh, we've got one. Okay. Let's see. This might be too specific. I'm not sure yet. I have a question in regards to a mentally ill landlord. I want to protect myself upon moving out. I have 1.5 months left in my lease. I have taken pictures of the home before moving in and have all conversations documented, but I'm worried she will try to either not return my security deposit or create a false list of repairs needed to the home and invoice me. No damages were made. What can I do to protect myself now? And is there a way to report her as an unfit landlord to prevent another person from having to deal with all I have dealt with? It sounds like she's very mentally unwell, and there have been orders of protection against her made by the neighbors.
Okay, so in terms of the mental illness, no, but in terms of not making repairs, if you've reported to the buildings department, they would remain part of the record. In terms of the security deposit, taking pictures of the apartment before you leave is crucial to show that you left it in good shape. And if you don't get your security deposit back, you can file a complaint with the Attorney General, or you can start a small claims action, which is not that
Uh,
complicated to do.
That was me. So it's a private home that I'm renting. It's not public
It doesn't
apartment
matter.
housing.
It doesn't matter.
Okay, I was trying to type, but you were talking so fast. Could you repeat the last two sentences that you just
Oh, the
said?
small claims. If you can't get your security deposit back, or they deduct too much, you can sue in small claims court, which is part of the town and village court.
Okay, thank you.
If you're in Shelter Island. If you're further up in Suffolk, then it would be district court. So
I'm in
Western Suffolk, it's
Huntington.
district court. Where are you?
Huntington.
Then it would be the district court that's on New York Avenue.
Okay, thank you.
Okay.
we have another question. If you're served with an eviction notice, what happens on the first day you go to court? Is it correct that the judge will not appoint you a lawyer as in criminal court cases?
No, there are no, unfortunately, appointed lawyers for civil cases. However, Long Island Legal Services is often in the courthouse. It depends on the court as to when they're there. The judge will give you an opportunity to try to get a legal services legal aid attorney, but then you have to be qualified by income and immigration status to get their help. If you're not, there is no such thing as an appointed attorney in an eviction case, and that's sad. But that's where we're at this point in this country.
And someone left a comment. So the person looking for Section 8 senior or disabled housing, contact Highlandia in RVC Baldwin Island Park and more, Broadwell Management, which is in Nassau County. So just sharing
Right.
information there,
Right.
which is
It's
great.
it's difficult to find Section 8 housing, either project-based, meaning the entire building is Section 8, and if you have a voucher, more and more landlords are not taking the vouchers. So it is difficult to get a Section 8 place now.
Definitely. Does anyone else have any further questions? Not seeing anything come through in the chat. But of course, you guys are free to email Legal Hand. You can also reach out to me if you're registered with the Shelter Island Library with questions, and I can kind of pass them along at the best I'm able, or share contact information to everyone at Legal Hand.
Right. And you can
Stephen is
text us
connected as
or
well.
call us if you feel more
Yep.
comfortable with that
Yep.
means of communication. We
Yeah,
find that
perfect.
young people love to text.
I
People
imagine the
my
best.
age, not so much.
Yeah, as a texter myself, I
Mm.
absolutely agree. All right. Well, thank you so much, Judge Fisher. This has been very helpful. Great information shared here. And I thank everyone for spending their Friday afternoon and evening with us.
Thank you much. We
All
appreciate
right.
it.
Thanks, everyone. Have a great night.
Okay, bye-bye.